Good evening, Judge, classmates. Tonight, I will be reporting on Sections 3 and 4, Rule 133. Section 3 provides that extrajudicial confession not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless it is corroborated by evidence of corpus delicti. Now let us understand the effects of a judicial and extrajudicial confession. A judicial confession is sufficient in itself to sustain a conviction even in capital offenses. On the other hand, an extrajudicial confession is insufficient in itself to sustain a conviction. It must be corroborated by evidence of corpus delicti. In the case of People v. Porio, JR number 117202, February 13, 2002, a confession is defined as an acknowledgement in express words by the accused in a criminal case of the truth of the main fact charge or some essential parts thereof. Well, owing to its very definition, there is no such thing as an implied confession. It is always direct and positive acknowledgement of guilt. You can see on the screen the requisites for admissibility. So for confession to be admitted, the following must concur. First, the confession must be voluntary. Second, the confession made with the assistance of a competent and independent counsel, preferably of the confessant's choice. Third, the confession must be in writing. And lastly, the confession must be expressed. What is corpus delicti? It refers to a particular crime and signifies that the specific offense had been actually committed by someone. So People versus Ricky Kiamzon, GR number 133541, April 14, 2004. In the case of murder, corpus delicti does not refer to the autopsy report evidencing the nature of the wounds sustained by the victim, nor the testimony of the physician conducted the autopsy or the medical examination. It is always made up of two elements. Now, the first element is that a certain result has been proved. For example, a man has died. Second, that someone or some person is criminally liable for the act. While the autopsy report of a medical legal, of a legal expert in cases of murder or homicide is preferably accepted to show the extent of injuries suffered by the victim, it is not the only competent evidence to prove the injuries and the fact of death. It may be proved by the testimonies of a credible witness. Even a single witness, uncorroborated testimony, if credible, may suffice to prove it and warrant a conviction thereof. Extrajudicial confession is governed by these following rules. The general rule is that the extrajudicial confession of an accused is binding only upon himself and is not admissible against his co-accused. While the exemptions are, if the confession is an interlocking confession, i.e., extrajudicial confessions independently made without collusion, which are identical with each other in their material respects and confirmatory of the other. Second, if the co-accused impliedly adopted said confession by not questioning its truthfulness. And third, where the accused admitted the facts stated by the confessant after being apprised of such confession. Fourth, if the accused are charged as co-conspirators of a crime which was confessed by one of the accused and said confession is used only as corroborative evidence. Fifth, where the confession is used as circumstantial evidence to show the probability of participation by the conspirators. And six, where the confessant testify for his co-defendants. Seventh, where the co-conspirators' extrajudicial confession is corroborated by other evidence of record. Question: would a validly obtained extrajudicial confession alone be sufficient to prove conviction? The answer: no. As we've learned earlier, it must be corroborated by evidence of corpus delicti, meaning that there should be some evidence tending to show the commission of the crime apart from the confession. Now let's proceed with section 4. Circumstantial evidence when sufficient. So circumstantial evidence is sufficient for conviction if, number 1, there is more than one circumstance. Second, the facts from which the inferences are derived are proven. And lastly, the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. In the case of People v. Bronyola, GR number 211027, June 29, 2015, circumstantial evidence consists of proof of collateral facts and circumstances from which the existence of the main fact may be inferred according to reasons and common experience. Example: number 1, when fingerprints were found in the crime scene, and such fingerprints belongs to the accused. Second example: if an assault happened on the 21st Street, Nazareth, Cagayan de Oro City at 6:15 p.m., a witness can give evidence that he saw the accused walking down the same street, 21st Street, Nazareth, Cagayan de Oro City at 6 p.m. Conviction is possible if the established circumstances constitute an unbroken chain consistent with each other and to the hypothesis that the accused is guilty. For the nature of circumstantial evidence, as you can see on the screen, you can see there a puzzle. So in the case of People v. Monhead, GR number 146689, September 27, 2002, the Supreme Court characterized circumstantial evidence as a puzzle pieces, which, when put together, reveal a convincing picture pointing to the conclusion that the accused is the author of the crime. In the case of Almuela versus People, GR number 183202, June 2, 2014, a finding of guilt is still possible despite the absence of a direct evidence. Conviction based on circumstantial evidence may result if sufficient circumstances proven and taken together create an unbroken chain leading to the reasonable conclusion that the accused, to the exclusion of all others, was the author of the crime. The reason for its admission: it is due to the necessity, especially in a criminal case. If only direct evidence is allowed, very few convictions could be had. Besides, circumstantial evidence is based on sound, rational grounds of everyday logic. The following are the guidelines in conviction based on circumstantial evidence. First, circumstantial evidence should be acted upon with caution. Second, all of the essential facts must be consistent with the hypothesis of guilt. Third, that the facts must exclude every other theories but that of the guilt of the accused. And fourth, the peculiarity of circumstantial evidence is that the series of events pointing to the commission of a felony is appreciated not singly but collectively. That ends my topic. Thank you, and once again, good evening.